Hello and welcome to this online CPD seminar. The subject is going to be Crofting Law in 2023, 10 risks to watch out for. My name's Eilidh. I'm a former practising solicitor, now non-practising solicitor and Crofting Law consultant. The 10 risks that we're going to be looking at today are: number 1, advising your client about buying a croft. Number 2, croft registration. Don't listen when they say it's easy. Number 3, croft status, the most important and the most misunderstood issue in crofting law at the moment. Number 4, purchasing a croft from a landlord. Number 5, don't forget the common grazing shares. Number 6, acting for landlords. Number 7, croft succession, a very fiddly and high risk affair. Number 8, penalties for failing to register a regulatory decision. Number 9, crofting law versus agricultural law. And lastly, the marketing of croft land. So, our first topic, number 1, advising your client about buying a croft. If you are acting in the purchase of a croft, you should be satisfied that your client understands what it is they're buying. Best practice is to ask your client to confirm if they require to be advised on the crofting system itself before they proceed with the purchase. If your client confirms they do not require that advice, you can move on to the purchase itself. Otherwise, and in particular, if your client is not from the crofting areas or living outside the crofting counties, you will want to advise them fully of the risks of the crofting system. I usually cover at least the following general matters. Firstly, the statutory conditions and duties of a crofter, principally residency and use of the croft. Also, penalties for breach of those statutory conditions and duties. What can a croft be used for, including diversified uses? Will your client be able to get planning permission for a house or for other residential, commercial or agricultural developments? And also the role of the Crofting Commission and the Scottish Land Court. You can also direct your client to some websites for general reading. I have a list of resources available on my website and I've given you a link there. It's really important when you're drafting missives for the purchase of a croft that you address, amongst other things, the following matters. The date of entry is obviously very important. For tenanted crofts, this is usually defined by the legislation, which is principally the Crofters Scotland Act 1993, and the date of entry will vary according to whether the croft is registered on the crofting register or not. And the date of entry, I would say, is one of the things that I see in missives most often that people have got wrong. Next up is croft status. Again, it's fundamental to your client's plans for the croft, so really important that you get this covered off in the missives. You'll need to carry out your own status investigation during the title examination stage, or the equivalent for tenanted crofts, but you should also provide for the seller warranting the status of the croft. Next up, you should provide for the transfer of any agricultural entitlements or subsidies, if any exist. You should be asking for a warranty that there are no third-party rights affecting the croft. You should ensure that the contract for the purchase of a tenanted croft or grazing share is conditional upon the consent of the Crofting Commission. You might also want to include a long stop date. And finally, you might also want to incorporate some of the Scottish standard clauses, but obviously others you won't find are relevant. So moving on to part 2, croft registration and the crofting register. There are 2 registers of crofting interests. Firstly, the Register of Crofts, and secondly, the Crofting Register. They are in some ways akin to the General Register of Sazines and the Land Register, in that the former is older and not map-based, and the latter is more modern and is map-based. Another similarity is that there is a rolling process of registration onto the new Crofting Register, which was established in 2010. If one hits a trigger, there is a requirement to go through the process of first registration, but one can also register voluntarily. The rationale behind the creation of the Crofting Register was the requirement for clarity and certainty in relation to croft boundaries in the event that a particular croft was to be used as security for a mortgage. back in 2008, 2009, the prospect of croft mortgages was on the legislative table, so to speak. And although the mortgage provisions themselves did not make it into the 2010 legislation, the Crofting Register itself did, which is, since that time, we've had the two simultaneous registers of crofting interests. The Scottish Government and the Registers of Scotland were at pains back in 2010 and 2011 to tell crofters and agents how easy and inexpensive the process of first registration would be. Crofters were assured that they could do the applications and the mapping required for themselves, and that no professional input would be required. Now, while some croft registrations are indeed as straightforward as we were all told they were going to be, in my experience, that is very rarely the case, particularly where we're talking about an owned croft. Complex croft registrations comprise much of my caseload, and a good proportion of those are corrective cases where the original registration has been incorrectly executed and action is required to ensure that the correct legal position is reflected. I would say in my experience, where we're talking about owned crofts, I would say as many as sort of 80 to 90% of crofts which have been registered already, when they come to me, have been done incorrectly. And the principal problem is that the title boundaries do not match the registered boundaries, and also that the various split-off deeds haven't been properly accounted for, and also that the various decrofting directions and resumption orders haven't been properly mapped. So in order to register a croft correctly, one must establish the following. Firstly, the external boundaries of the croft. And I always make it really clear to clients, some of whom think that I have sort of an encyclopedic knowledge of all croft boundaries. Make it clear to your client that you don't know anything. You've got no personal knowledge about their croft boundaries, unless you do, of course. If the croft is owned, you've got to examine the titles and any split-off writs and use these to inform the boundaries. Get yourself a good mapper who knows how to do croft mapping. You've also got to map any areas which have been removed from the extent of the croft by decrofting or resumption. Any areas which have been apportioned from the common grazings will form part of the croft, and you've also got to look at that in relation to the title deed. Depending on when the apportionment order was granted and when the title deed was granted, there will be some differences in how those have got to be registered. All of that data, as I said, should be plotted on the OS plan, on an OS-based map by a mapper who's experienced in dealing with croft registration plans. The format is quite particular, and your application will be rejected if it doesn't comply with those criteria. The application form must also be completed correctly and sent to the Commission with the plan. It's really important when you're dealing with the application form that you list on there the correct neighbours of the croft. So I always ask my clients for a list of all of the owners or croft tenants who own land which shares a boundary with the croft, and make sure you get a full list of those from your client. And again, make it clear that you don't have personal knowledge of that. You're relying on your client to inform you. If the incorrect parties are not listed on your Form A, on your croft registration application form, it can mean that a challenge can be brought after the 9-month period. That 9-month period that I just mentioned, once you send off your application and your plan to the Crofters Commission, they then register the croft, it's passed to the Crofting Register, and there then follows a 9-month period within which the boundaries can be challenged to the Scottish Land Court. But if you haven't done your application correctly and informed the correct parties, there is a danger that deadline won't apply, and so a later challenge could well be brought. As I said, after that period, that the boundaries are somewhat safe from challenge, but there are some circumstances where you can challenge after the 9-month period. It's also important to watch out for neighbouring crofts being registered, just in case that they've been done incorrectly. If I lived in a crofting township, I always tell my clients I'd be keeping a beady eye on the Crofting Register, just to make sure that I knew exactly when everybody's croft had been registered. In terms of, so I've I've been talking about the challenge there. Now, a challenge to a croft registration is a challenge brought by a third party, but it's also possible for the croft to be rectified by the original applicant or by the original applicant's executor. And there's no time limit on that. So some common problems with croft registrations. First of all, crofts being registered without any reference to title deeds. So that is going to lead to problems with the status of the croft. Secondly, crofts being registered without notifying all the relevant parties. That is all parties who share a boundary with the croft or any part of it. Thirdly, crofts being registered without reference to resumption, decrofting or apportionment orders. Fourthly, crofts being registered without reference to the boundaries of any existing registered common grazing, so you might have an overlap or an underlap. These problems can be extremely tricky to sort out after the croft has been registered, so it's really important to really stress to your client how important it is to get these registrations done done correctly first time around. So now that I've said my bit about croft registration, the next section that we're going to be talking about is to do with croft status and the curse of section 19B. So croft status problems really have only become an issue since the last Act was passed in 2010. Before 1976, all crofts were tenanted crofts. It was a system of tenancy. In 1976, the right to buy came in, and many crofters exercised that right to buy and became owner-occupiers. So that term has been around since about 1976, although it was never actually defined in law. However, because of the lack of a definition, the whole crofting system, although there was this one section of the 93 Act which allowed crofters to purchase their croft, the rest of the provisions of the Act, which were regulatory provisions, penalising crofters for not doing this or that, they didn't apply to anybody other than tenant crofters. And so it became clear that these owner-occupiers who had a title to their croft were slipping through the regulatory net. So the Crofting Reform Scotland Act 2010 defined owner-occupier crofters and attempted to provide for their effective regulation. So the new definitions of owner-occupied croft and owner-occupier crofter are contained in section 19B of the Crofters Scotland Act 1993. And it's the legislative structure of those definitions which has caused the problem. And so looking back, you've got to be the owner of a croft, not part of a croft. So you fall foul of section 19B subsection 2, which is that's a big problem. So yeah, the upshot of these different definitions of owner-occupier are that there are now 3 categories of crofter. Firstly, tenant crofters. Secondly, owner-occupier crofters who comply with the definition in section 19B. And 3, landlords of a vacant croft, who are that's the kind of sweep-up definition for everybody who isn't a tenant crofter and isn't an owner-occupier crofter either. So how do you spot a croft cursed by section 19B2? Well, it's not easy. So firstly, you have to check the Crofters Commission's Register of Crofts. If the copy entry lists no owner-occupier, but instead a landlord, you have a problem. Equally, even if you check the Register of Crofts and it says that the crofter is an owner-occupier crofter, unfortunately, you cannot take that as being correct. That's because the Register of Crofts is only as good as the information which is provided to the Crofters Commission, and frequently over the years people have failed to advise the Commission of the purchase of croftland, and that's created lots of these problems. So really, whether the copy entry is showing the croft as owner-occupied or whether it's a cursed croft, you're going to have some further work to do. So the the status of the croft, i.e. whether it's an owner-occupied croft or whether it's a vacant croft, will have pretty significant implications for your client's use of the croft, and in particular for their ability to obtain grant funding. Now, that might not bother your client, or it might be a huge problem for them. So just make sure that you're advising them fully on that and that they know what it is that they're buying. So here we go. You cannot benefit from either of the crofting grant schemes, so either the Croft House grant scheme or the Crofting Counties Agricultural grant scheme. Theoretically, the Commission could regulate you as the landlord of a vacant croft, even if in practice they don't do that. You're legally tied to the owners of the other part of your croft. You cannot grant a short-term tenancy over the croft. You cannot apply to divide the croft. And really, because of all of that, the value can be diminished. So the remedies available to change the status from vacant to owner-occupied are as follows. So the easiest solution is to decroft if it's a little bit that's owned by a third party, by far the easiest thing to do is to decroft that little bit. However, the Commission are very reluctant to decroft anything for which planning permission doesn't exist. So that can be a bit of a headache to get that through. Sometimes I've had some success with it, but sometimes the Commission will refuse to grant a decrofting direction. The other thing that you can do, the other remedy that your client may have, is to divide the croft by letting a tenancy over the bit that your client owns, and that letting application will have the effect of dividing that away from the area of the croft that's owned by other parties. You will then have a situation where the bit that your client owns, there's a landlord and tenant situation. You have to be careful if the landlord and tenant, i.e. your client and the person that they're letting the tenancy to, if they're not a married couple, you need to be very careful, and perhaps you need to have a minute of agreement just to cover that off and make sure that your client is not disadvantaged. So a different type of status problem has been brought about by Section 19D of the 1993 Act. And that provides that an owner-occupier crofter may not transfer, whether or not for valuable consideration, ownership of any part of the owner-occupier's croft without first dividing the croft into the part which the owner-occupier proposes to transfer and the part which the owner-occupier crofter proposes to retain. Section 19D6, any transfer of ownership which is not a new croft created by a division, and any deed purporting to transfer ownership of that part is null and void. So this is actually as catastrophic as it sounds. If the croft is an owner-occupied croft, and bear in mind it may not be, but if you look at the status and confirm that it is in fact an owner-occupied croft, and part is transferred without being first divided or decrofted, the title deed will be null and void. And I'm absolutely sure that there's quite a number of title deeds out there which are excuse me, null and void, but just simply have not been discovered yet. Transfers which took place before the 2010 Act came into force are exempt. So on that cheery note of null and void title deeds and the panic button, that brings our section on croft status to an end. Our next section is croft purchase by a tenant from their landlord. So a tenant crofter has two distinctive rights to buy. Firstly, a qualified right for a crofter to apply to the land court for an order authorising acquisition of his croft if he can't agree the terms with the landlord. And two, the entitlement of a crofter to acquire a title deed to the site of the dwelling house on or pertaining to the croft, which is often called the croft house site or the statutory house site. So each croft gets a kind of an allowance of a statutory house site. It must be an existing house. It cannot be a plot with planning permission. There has to be an existing croft house. It must be wind and watertight and fit for human habitation. Croft land is defined in Section 12.3 of the 1993 Act and covers everything else. It includes an apportionment which is contiguous or adjacent to any part of the croft. The terms contiguous and adjacent mean respectively in actual contact and close or neighbouring. So the latter is a wider term than the former. A freestanding apportionment does not fall within Section 12.3, and therefore it's really important that if you want to buy your apportionment, you have to get the apportionment first, and then you apply to purchase the apportionment with your croft land. Mineral rights fall out with the definition of croft land, and a crofter has no right to acquire those. Normally mineral rights appear by way of a reservation in the disposition, and you would normally also expect to see rights for compensation if the landlord is ever going to work those mineral rights. Previously, a crofter could nominate any third party in whose name they wished title to the croft land to be conveyed by the landlord of the croft. So this was what was called a nominee procedure. And it resulted, when I was first in practice in sort of 2008, 2009, it resulted in a huge number of plots changing hands, with landlords receiving maybe a couple of £100 for the plot and the crofter receiving the full market value of a plot with planning permission. It seemed to be generally accepted that the pendulum perhaps had swung too far in favour of crofters, and the Crofting Reform Act 2010 actually closed that loophole, and so now it is the case that only a member of the crofter's family can be nominated to take title, and the crofter's family is defined by section 61(2), and it essentially goes up to first cousin, first cousin and closer is defined as the crofter's family. Anything out with first cousin is not. If you're a landlord and you don't want to sell the croft or the croft house site to the crofter, in relation to croft land, there are two objections available to a landlord. In relation to a statutory house site, there are no objections available to a landlord. A crofter is entitled to obtain a title deed to their croft house. In relation to croft land, the objections are, firstly, if it would cause a substantial degree of hardship to the landlord, and secondly, if it would be substantially detrimental to the sound management of the estate of which the croft is part. And it's proved very difficult over the years for a landlord to resist a crofter's acquisition of their croft land. The test for hardship is high, it must be more than loss, and the degree of hardship must be substantial. The purchase price to be paid by a crofter for their croft land, if they're acquiring the whole croft, is simply the annual rent multiplied by 15. If the crofter is to acquire only part of the croft, then the price is the proportion of the rent attributable to that part multiplied by 15. The purchase price for the purchase of a croft house site is the amount to be paid by a crofter of bare agricultural land with no planning permission and no hope value. And most of the time that works out at between £100 and £500 or thereabouts. If the landlord has provided fixed equipment, the crofter, in addition to the sum due in respect of the land, will be also required to pay 50% of the value attributable to that fixed equipment. A sporting lease, the crofter may be required to lease to the former landlord the shooting and fishing rights pertaining to the land for a period of not less than 20 years at nominal rent. In practice, shooting leases are pretty rare. However, where they are taken, invariably landlords seek sort of 90 or 100 years of a lease rather than 20. It's really important that if a sporting lease is granted back in favour of the former landlord, it should affect only the croft house, only the croft land, not the site of the croft house. The other thing to think about when you're purchasing a croft for a client is landlord's clawback. If a crofter or their nominee, having acquired croft land, then conveys the land or any part of it to a person out with their family within 10 years of the date of the original acquisition, the former landlord is entitled to a further payment. The previous period of 5 years was extended by the 2010 Act to 10 years. A former landlord's future right to clawback is usually secured by way of a standard security. And again, care must be taken to ensure that the security only affects the croft land, not the croft house. So next up, I'm going to talk about common grazing shares. A tenanted croft often will enjoy, as a pertinent of the tenancy, a right or share in a common grazing. and this will usually, although not always, be noted on the Register of Crofts. When the croft is purchased, the tenancy in respect of the croft land is extinguished by the operation of confusio, and that's been case law since 1988. Unless the share is specifically included in the conveyance, it will not carry automatically and will remain in tenancy and will thereafter become a deemed croft. So in my view, it's best practice not to include the grazing share in the conveyance, and that will result in a deemed croft. The reason it's best practice is because the alternative to the grazing share becoming a deemed croft is that the grazing share is carried with the conveyance and becomes a sort of, the Land Court have called it a quasi-servitude, which the legal position is as grey as you would expect it to be in something called a quasi-servitude. A rent will need to be paid, presuming that the grazing share remains in tenancy, as I've suggested. A rent will need to be paid to the croft landlord in respect of the deemed croft. And you should note that the landlord of the share may or not be the same person who actually owns the common grazing. So if the common grazing is in the landlord of person A and the croft is in the ownership of person B, the rent for the continuing grazing share, the continuing deemed croft, is actually payable to person B, the person that owns the croft, counterintuitively. Grazing shares are a potentially valuable asset in these days of natural capital and interest in carbon rights and so on. However, they're often forgotten, usually because they've become separated from the croft to which they originally pertained. The separation can happen in one of two ways. Firstly, if the croft was purchased from the landlord and the grazing share remained in tenancy, deemed crofts and grazing shares now have their own entries in the Register of Crofts and will also be registered on the new Crofting Register. Or if the tenancy has been divided at some stage, perhaps because it was going to be assigned to another crofter who had more use of it, and then at that point obviously the share and the grazing right are separate. If you are purchasing a tenanted croft, it's important to ask not only if the croft has a share as a pertinent of the tenancy, but also whether the seller has any extra shares which they might be willing to assign. If you are purchasing an owner-occupied croft or a vacant croft, otherwise known as a cursed croft, it's even more likely that the share could be forgotten. Ask questions, do some research. Many a grazing share has simply been forgotten, and the seller or the current tenant, if not the seller, may be happy to sell. If you've inherited an owned croft or a croft tenancy, or are the executor of a deceased crofter, it's even more important to find out about the correct legal position regarding the grazing shares. So that brings the section on grazing shares to an end, and I'm going to talk briefly now about acting for landlords. A landlord's rights can be found in Schedule 2 to the 1993 Act, and there's a link there. In particular, paragraph 11 is helpful, which lists that a landlord has rights over a tenanted croft to take minerals, stone, use springs of water, cut or take timber or peats except trees planted by the crofter, make roads, ditches, fences, watercourses, and to hunt, shoot, fish, or take wild game birds or vermin. If a landlord wishes to take action against a crofter who is perceived to be in breach of one of these statutory conditions, the landlord must raise an action in the Scottish Land Court. Removal of a crofter by the landlord is difficult and rare. However, a landlord must take great care in taking such an action, because if the tenancy is terminated as a result of that action, the crofter is entitled to claim compensation for any permanent improvements which have been made to the croft by the crofter or his predecessor. So permanent improvements can include houses, buildings, that will vary from croft to croft, so do take care with that. Since 2003, it's been possible for a landlord, when creating a fresh croft tenancy, so you've got a vacant croft and a fresh croft tenancy is going to be created, it's been possible since 2003 to vary the statutory terms and conditions of tenure. And this provision was brought in at the same time as the provision to allow new crofts to be created. And the hope was that more crofts, there was more of a an encouragement to create new crofts if the landlord could vary the statutory terms so that it was less punitive from a landlord's perspective. The take-up of new crofts and the amended terms of tenure has been surprisingly low. There are instances, of course, where the benefits have been exercised, but it is still quite rare. A landlord can remove, amongst other things, the right to purchase, the right to decroft, the right to divide, to assign, to bequeath the tenancy, or to have it treated as part of the crofter's intestate estate upon death. And restriction of some of these rights requires the prior approval of the Scottish Land Court. Now that brings us to the end of that short section on landlords. Moving on now to croft succession. If a croft tenancy is the subject of a valid bequest, the beneficiary has 12 months from the date of the crofter's death to accept the bequest and attend to the formalities. If there's no will, or if the bequest is not valid, or if the valid bequest was not dealt with within the 12-month period, the tenancy will need to be dealt with by a confirmed executor according to the rules of intestate succession and within 24 months of the date of the crofter's death. These time limits do not apply to owned crofts, but watch out for the separated grazing share, which will be in tenancy, likely, and therefore will be subject to the time limits. So even if you have an owned croft, you think you're in the clear, double check to make sure there's no grazing share that you have to be mindful of time limits for. If the tenancy has not been transferred within 24 months of the crofter's death, it will be open to termination at the hand of the landlord or the Crofters Commission. There's been some useful case law around croft succession. Gardner against Curran held that no specific bequest of a croft tenancy in a crofter's will is necessary. Regardless of that case law, I always advise clients when writing a will to draft a specific bequest for each tenancy, just as a belt and braces. The case of McGrath against Nelson in 2011, citation is there, provided that one way in which to transfer a tenancy on intestacy is for the confirmed executor to use a docket endorsed on the grant of confirmation. The more recent case of Pattinson against Matheson from 2021 has clarified that a tenancy may still be transferred after 24 months, although it is still at risk after 24 months. A croft tenancy may be bequeathed to more than one person, but the executor in that case would require to apply to the Commission to divide the croft. Now, there's no guarantee that the Commission would approve that application. There are some quite strict policies around division, and therefore and of course if the division application was refused by the Commission, the bequest would then fall into intestacy, and that may change things pretty significantly. So I always advise clients not to proceed in this way and instead to bequeath to a single natural person. A landlord has no right to object to a legatee. The Commission's role in the process, as well as they're not approving the legatee, the beneficiary, they're simply updating their records to show that they've received information, to show that the croft tenancy was bequeathed and that the bequest was accepted. The Commission do not look behind the copy of the acceptance, and they take it at face value. There are some quite prescriptive procedures around croft succession, and these must be followed to the letter in order to safeguard the tenancy. If the croft has not yet been registered on the Crofting Register, you'll need to lodge an application for first registration at the same time as you lodge copies of the succession notifications. And again, I'm going on about this. Please don't forget the grazing shares. Cross-check on the registers to make sure that they haven't become separated. Separate succession notifications may well be required. Our next very short section is to do with the updating the Crofting Register following a regulatory decision. So if a regulatory application is granted in respect of a croft already registered on the Crofting Register, you will be required to update the Crofting Register within a period of 3 months from the date of the decision letter. The form is very simple and there's a £90 fee. So it's a very straightforward procedure, but if you fail to do it, the regulatory decision will fall and you will have to reapply. And at best that can be frustrating and at worst it can be catastrophic because there's no guarantee, of course, that the Commission will come to the same conclusion the second time around. Next up is just a very brief word on crofting law versus agricultural law. The first point to make here is that land can either be designated as croft land or as agricultural holdings land. The two designations are mutually exclusive. Land designated under the agricultural holdings legislation is usually let either on some form of tenancy or it's let seasonally. And indeed, it's important that some form of paperwork, however rough and ready, is agreed between parties and duly executed, because in the absence of such paperwork, longer-term tenancy rights may be established. However, that's not the case where the land is croft land, and any tenancy arrangements over croft land must go through the Crofting Commission. If an arrangement has not been authorised by the Crofting Commission, it has no legal effect. And furthermore, if there is occupation but no paperwork, whether via the Crofters Commission or otherwise, the person occupying cannot and will not establish any rights of tenancy over the land. And this is the case even if the land is changing hands or has changed hands. Next up is the marketing of crofts. So it's the market in crofts and croft tenancies has been, to say the least, pretty strong really since about late 2020, the lifting of the lockdown provisions. It's really taken off, and there's been an associated huge rise in land values. However, one thing I've noticed over that same time frame is a great deal of carelessness coming in when drafting particulars for the sale of crofts. I routinely see very badly drafted sales particulars talking about owner-occupied croft, which I know haven't been confirmed as such. It's also now very common to see croft sales particulars mention planning permission as if it will be granted by right, and that is simply not the case. And at best, it's misleading, and at worst, a cynical attempt to further heat up the market by feeding into the croft land as development land narrative. It is possible, of course, to use the statutory duties and conditions as arguments in any planning application or planning appeal, i.e. the applicant must be resident and work the croft and therefore planning should be granted. Agricultural considerations can also be used to seek to persuade the local authority that planning should be granted. For example, the applicant has X number of sheep on their holding, therefore a residential base on the holding is required, therefore planning should be granted. But local authorities are not obliged to grant planning permission on croft land, even if those arguments are employed. Local authorities can and do refuse planning permission on croft land, just as they refuse planning permission in respect of non-croft land. So that brings me to the end. You'll need one of those after a seminar on crofting law. Thank you very much for listening to this seminar. I hope it was useful, and you can see my biography and the services I offer on my website. And yes, I hope you find it helpful, and thanks very much.